Welcome again to the Money Laundering Research Network webinar of the month of October. With Miles Kellerman from Leiden University presenting on licensed detection agents, the case for financial crime bounty hunters. Discussant will be Mark Tarkington, consultant and former group head financial crime detection of HSBC. So as usual, we will have about 15 to 20 minutes presentation by Miles, then 15 to 20 minutes discussion by Mark, and then open floor for Q&A. So thank you again for joining. The floor is yours. Please, Miles, you can go.
Thank you, and thank you very much for the opportunity to present. I've been joining these webinars for the past few months since they started. Actually, maybe it's already been a year or so, and it's a great initiative. And as I was working on this paper, I couldn't think of a better group of scholars to present this to. So I'm very much looking forward to this. And I also wanted to say special thanks to Mark for serving as a discussant, and I'm really looking forward to your comments. So, as mentioned, today I'll be presenting a paper titled Licensed Detection Agents, the Case for Financial Crime Bounty Hunters. And this is not an empirical paper, so as it sounds, this is actually more of a policy proposal. So it's for those who may have not been on the call earlier, I'm also trying to figure out, where this might fit in terms of trying to look for a venue for publication. But just FYI, so it won't be an empirical results to be presenting, it will be a proposal for a new idea. Now, I'm currently an assistant professor at Leiden University at the Institute of Security and Global Affairs. But prior to joining Leiden, I was working in the private sector. So I've worked in-house at UBS, and I also worked at a couple of different consultancies. And to start off with, I wanted to provide a bit of a personal anecdote, a bit of background on sort of how I got to this place and sort of the background on where this comes from. So when I was working in the private sector, much of my activities centered on corporate monitorships. And so I think a lot of people on this call will already be familiar, but for those who aren't, corporate monitorships are a special type of enforcement tool, and they tend to arise when a financial institution has been found to have engaged really in law violations at scale. These are big cases, the types of big scandal headlines that we're used to seeing. And essentially, the use of a corporate monitor arises when a prosecutor decides that they will offer the company an opportunity to improve their compliance controls. And so essentially, it's a deal, it's a bargain. And in the US, they call this a deferred prosecution agreement. In the UK context, this is referred to as a Section 166 skilled person report, but it's very much the same kind of process. And essentially, they say to the company, if you improve your controls in the set time period, then we will not bring criminal charges against you in court. But the question is, how do you determine that the company is actually making these improvements? And that's where the monitor steps in. And so this is generally an individual, usually a former prosecutor, who is assigned as an independent third party to oversee whether these improvements are being made. And generally, the monitor tends to surround themselves with consultants, and they go off all over the world, going to different branches of a bank or whatever the institution may be, and they perform on-site inspections. And I was one of those consultants. So that was really my main bread and butter when I was working in the industry, was working on corporate monitorships. And in 2016, I participated in my first ever corporate monitorship, very new, very naive in many ways. And while I was there, I made what I thought was a great big discovery. So I was reviewing these files. We had taken a sample of customer files from this particular bank. And essentially, I was responsible for reperforming the due diligence checks to see if they had been done correctly. And when I was doing that, I discovered that one of the clients of this particular bank was connected to a terrorist organization. And so I thought, wow. Fantastic. I've made this big discovery. My bosses are going to love me. And so I was so excited and excited to present it to my bosses at the time. And I would describe the reaction as bemusement. They were not so impressed. And so what I quickly learned was that these types of violations happen all the time. And for them, this was a really normal course of action, not really so special. So I bring this up as an anecdote, but it points towards a wider problem currently in the industry, which is that we have a lot of issues with what I refer to as the gatekeeper model. And so the gatekeeper model is a general regulatory approach where states have essentially outsourced frontline detection to the private sector. And so this is applicable in the money laundering arena with anti-money laundering controls, but it's also very much the case when it comes to things like insider trading and manipulation, where we have outsourced detection primarily to exchanges, broker-dealers, hedge funds, etc. So this is a model that's being used throughout the industry to address various types of financial crimes. And what that generally entails, there are many tasks involved. Some of the core ones are performing due diligence on customers, assessing their risk and assigning a risk rating, performing ongoing continuous monitoring of their transactions, which will be a big focus of today, and additionally reporting. So reporting in the AML space, submitting suspicious activity reports, and in Europe they call these stores when it comes to manipulation, but it's a similar process. So essentially, what governments around the world have done is outsource this task to the private sector and ask them to act as extensions of law enforcement, monitor their own clients, and when they identify something suspicious, to report that back to regulators and prosecutors. So this system is very expensive. So in 2023, the private sector spent approximately $200 billion on their AML obligations. And this does not include the additional billions that have been spent by other types of institutions on their market abuse controls. And additionally, this is one of my favorite stats. So here in the Netherlands, 20% of the banking sector is full-time dedicated to AML. Pretty remarkable statistic. Unfortunately, however, we're not getting great results for all of that investment. So the data quality around this topic is quite poor, but those estimates that do exist suggest that we are identifying less than 1% of global money laundering. And the rate of detection is not very better in other areas of financial crime. So there has been one study, for example, of something called closing price manipulation. It's a type of market manipulation. And for every single case of prosecuted closing price manipulation, it's been estimated that there are 308 to 326 additional cases that are not identified. And this is just one type of manipulation and just one type of asset class. Additionally, we also fail to see 2/3 of corporate fraud. So the empirical evidence that we have for the gatekeeper model is not good. It's essentially that we're paying an enormous amount of money and we're not getting great results. So the question motivating the paper, first and foremost, is why? Why is this gatekeeper model failing? And there are many factors. One is that the regulatory expectations themselves, they're not always clear. There's certainly many areas of AML and market abuse provisions that are open to interpretation. Additionally, there is a poor level of feedback from regulators to the private sector. So a common complaint within the industry from compliance officers is that they put a lot of work into putting together these suspicious activity reports. They submit them to regulators and they never hear anything. They don't actually know what was happening with the SARS. They don't get that feedback, which in turn is a bit of a disincentive to try as hard as perhaps you might if you knew that your work was being used correctly. Part of the reason why, and a wider issue, is that also many regulatory agencies are underfunded. So there are plenty of post-detection issues. There may be many cases where banks and other institutions are submitting SARs, but they're not actually being taken up by prosecutors, perhaps because they're getting so many SARs or they don't have the sufficient resources. Additionally, there are data limitations. So as many people on this call know, many complex forms of financial crime involve multiple financial institutions. And so the capacity of any one institution to identify those schemes can sometimes be limited. So there's lots of contributing factors to this problem, but the biggest issue, in my view, by far, is the conflict of interest at play. There is an inherent conflict of interest of relying on private firms to monitor their own customers, and specifically the conflict between their desire to comply and the desire to maximize profit in very simple terms. And this can emanate in many ways. There is the type of very blatant assistance that we sometimes see in enforcement actions, but this can also come across in more subtle but important factors, things like not investing sufficiently in a compliance system, allowing poor software to continue and having additional consultant projects come through on a regular basis without actually ever making improvements, a general deprioritization of compliance as a function. And there's all kinds of additional small procedural decisions, corporate governance issues that come into play, and they all really emanate from this basic conflict, where the fact is that private sector, they don't really want to act as extensions of law enforcement. They're being forced to do this, and it very much conflicts in many instances with their commercial objectives. And some of the numbers themselves are striking. So between 2007 and 22, we had $56 billion in fines on gatekeepers for AML and sanctions failures. That number is now over $60 billion through 2024. And a particular survey of US firms found that 75% choose to incur AML violations all the time or regularly as a cost of doing business. And in addition to the numbers, we can also look at many different examples. We just had a massive enforcement action against TD Bank. We also have examples from HSBC, sorry, Mark. And of course, earlier last year, we had Binance's very large settlement. This is just a very small selection of enforcement actions. As many people on this call are aware, there are many financial institutions that are essentially in a constant, never-ending state of non-compliance, where they're just in a cycle of paying fines, having remediation exercises, paying fines again. So the picture is bleak.
Zoom.
I heard a noise there. I'm not sure what it was, but I'm going to continue. So the question is, what is the alternative? And I think if we take a step back and think about, if we were to design a surveillance system for detecting financial crime, what are the attributes of that system that we would want to see? And in the paper, I concentrate on 3 elements. The first is data access. So this is the basic capacity of whatever actor is performing surveillance to actually see the information necessary to identify financial crime. The second are positive incentives. Ideally, we would like that the agents performing surveillance are actually motivated to perform this well and don't have contrasting incentives that might undermine their motivations. And the final one is privacy protection. And what I'm talking about here specifically is privacy protection vis-a-vis the state. So many of us have concerns about the government monitoring our financial transactions. This has oftentimes been a political objection to surveillance. And ideally, we would want to be able to identify financial crime and minimize the amount of exposure of privacy for those who are innocent to the extent possible. And so if we look at the current gatekeeper model, there is data access. These firms themselves are facilitating the transactions. The problem, as I mentioned, is the lack of positive incentives. They do feature a high level of privacy protection, generally don't share customer data with the state unless they're obliged to. But that positive incentive element is missing. Another option that we could consider is government surveillance. So we could allow regulatory agencies themselves to directly surveil our transactions. And in a system like this, there would be data access. The regulatory agency would have the information it needs, and they would have positive incentives. So unlike a gatekeeper, most regulatory agencies would be positively incentivized to perform effective monitoring. The problem is the privacy protection. So many of us have concerns about the government monitoring every financial move. And an additional type of surveillance system that we can consider, and that I started the presentation with, is the corporate monitorship. And this is really a type of indirect surveillance mechanism, in that when performing a monitorship, teams can identify information that wasn't previously identified and then are generally obligated to report that to the regulator in that particular case. And so you can uncover new information during that process. The problem is that the data access is limited. So that type of indirect detection mechanism, it really only would arise if that information happens to be in the samples that are selected. And the monitor company has quite a lot of control over how they distribute documents to the corporate monitor. So it's quite a narrow type of detection. But there are positive incentives. There's lots of discussion about the incentives of corporate monitors, which we can talk about. But generally, I would argue that the incentives are largely strong to identify and share newly discovered suspicious activity. And there's also a high level of privacy protection. So in these monitorships, customer data is not shared with the regulator unless necessary. So as you can see, none of these systems provide all 3 elements simultaneously. And so I characterize this in the paper as a trilemma. And that's what's portrayed in this figure here. And I call this the surveillance trilemma. And so as you can see, the 3 desirable elements are in bold and the different systems are in italics. And what this graph implies is that any one particular system can only provide the attributes that are adjoining. So any one system can't provide all 3 simultaneously. And so what I'm proposing in this paper is a new system, which I contend can provide all 3 at the same time. And I call this the License Detection Agent Program, or the LDA program. And really the fundamental idea behind the whole concept is to flip the incentive structure of the current system and create a competitive market for detecting suspicious activity. So the idea is that these types of actors will generate leads for law enforcement, and they're also able to do so in a way that minimizes the invasion of the privacy of those who are innocent parties. So if we take a step back and look at previous programs, there's quite a lot of historical precedent for this type of system. So one of the most important in the United States is called the False Claims Act. And this is a system in which private persons, which are referred to as relators, they can file lawsuits against other private persons who they allege are defrauding the US government. And this was really inspired by contractor fraud during the American Civil War. And the idea is that if you allow these private persons to bring them to court in the name of both themselves and the federal government, that they're able to have a monetary incentive similar to a whistleblower, where they're able to keep any percentage share of the winnings if they happen to succeed in court. And the idea was really put forward by a senator named Jacob Howard, and he was the primary author of this program. And he said that, the idea was to set a rug to catch a rug. So it's the idea of using monetary incentives to induce private citizens to act both on behalf of themselves as well as the government. And the fundamental concept behind all of this is a Latin term called civitas, and it translates to he who prosecutes for himself as well as for the king. And so the idea is that you can empower individuals to take other private individuals to court in the name of the US government. The US government gets to save costs, and the individual gets to keep a proportion of the proceeds. And this was used throughout the American colonies for all kinds of crimes in the past, things like catching mackerel out of season, late night parties, selling bread fraudulently, etc. And so in the US, the False Claims Act has been hugely successful. So for the paper, I went back and looked at the data as far back as possible. And this is looking at the data from 1987 to 2023 in inflation adjusted numbers. And what you're looking at in this figure are really two lines of data. The first is the total amount of settlements and judgments, the total value that were won in court through these procedures. And on the bottom is the proportion of that which went to relators, the private individuals who undertake these cases on behalf of the US government. And so during that period, the government paid relators about $12 billion in rewards in return for obtaining $72 billion in settlements and judgments. So it's not quite an investment, but if we were to think of it in investment terminology, the government's return has been about 490%. There's been a fantastic program for the US government. It's the number one way in which the US government identifies fraud, and the vast majority of these cases are brought forward by whistleblowers. But it's not the only example. So there are also many other types of programs. I won't go through each of these columns, but just to give a sense of the range here. There's also whistleblower reward programs. So this has been quite popular, not just in the financial crime space, but also in the tax crime space. There's also infamous examples like American bail bondsmen. There's also wildlife bounty hunting programs. So for thousands of years, there have been programs, usually on a local level, to provide money to those who can kill the most invasive species, for example. There's even software companies have bug bounty hunting programs. And this is where they provide financial rewards to private citizens who identify some kind of software vulnerability in their systems. There's many other examples not covered here. You can also think about short sellers, for example, in markets. And my understanding is that there's also certain crypto initiatives where there's some kind of payment for identifying issues. But the big point is that there's a lot of precedent for this. And as I talk about in the paper, the empirical evidence generally is quite supportive of this as an incentive structure. So how exactly would it work? So the LDA program that I proposed in the paper, it would create a new class of third-party firms, and they would be licensed to perform surveillance. They would be empowered with access to data to be able to monitor transactions, and they would be rewarded. And this schematic shows a very highly simplified concept here. And the basic idea here is the creation of this new class of firms who are essentially interpositioned between the government and the relevant data, and they obtain that data. So one is that the regulator could provide direct access where possible. So in some cases, the SEC, for example, has access to a consolidated database of securities trading, and they'll be able to make that available to LDAs. In other cases where regulators don't have that access, gatekeepers themselves would be obligated to make their data available to LDAs for the purpose of surveillance. That's the concept here. So who would act as LDAs? So the two prime candidates that I have in mind are consultancies and software providers. The first, there's a big booming industry for forensic and financial crime consultants. They perform many similar types of tasks, and I think they would be well prepared to perform this type of role. Additionally, there's a big industry for financial crime software for detection. And in this program, it would provide those software providers with an opportunity to apply their products to actual data. And one thing to note is that this is not a proposal to replace the entire gatekeeper system. So this would be an addition on top. And the reason why is that if we were to rely entirely on LDAs, there's a risk that if those LDAs go bust, if they go bankrupt, for example, there'd be a situation in which there would essentially be nobody monitoring these transactions. So through this program, the idea is not to relieve gatekeepers of their responsibilities, but to create an additional class of firms who have a different type of incentive structure to look for financial crime. Another clarifying point is that the gatekeepers themselves are not hiring the LDAs. That's not the way it's structured, at least as it currently designed in the paper. The idea is that these firms would be independently licensed and they would answer only to the regulators who they work with, not to the gatekeepers. Okay, so a few more details on the operations. So first in the licensing. So if a firm wanted to act as an LDA, the idea is that they would apply for a license to perform this function. And so in the US, there's much precedent for this. You can look at broker-dealer licensing. You can also look at SROs, so self-regulatory organizations, which are endowed with judicial enforcement powers. In the UK, you could perceive LDA as a new type of regulated activity. So it'd be something that firms would apply for authorization to perform. And that licensing would be conditional on maintaining certain standards, and that would include privacy protection, of course. Data access. So as mentioned, two different avenues for actually providing data access. One that regulators can provide it directly, or that gatekeepers would make that data available to LDAs. And one key note here is that as part of this system, the way I envision it is that I don't think that gatekeepers should be penalized for any control failures that LDAs identify. The idea is that the LDAs are not focused on the gatekeepers themselves. They're focused on their underlying client base. The reverse situation really would pit them against each other. I think it would replicate a lot of the traditional issues of whistleblowing. And so the idea is to provide gatekeepers with that guarantee that they themselves are not under the microscope here, that they're making their data available so that LDAs can focus on the actual criminals, which are the end target of these systems. And finally, the reward structure. So the reward structure, as I currently conceive of it in the paper, is twofold. One, and the biggest reward, is a percentage share of any penalties, disgorgements of ill-gotten gains, or confiscations as a result of the reports. So this is very similar to the whistleblowing reward system. And that's the big time ticket that can run into the hundreds of millions of dollars for whistleblowing reports, for example. But the problem that if you only have that one type of reward, it's kind of a tough sell because it takes a lot of funds to perform surveillance, and also these investigations take lots of time. It can be many years before there is a report actually leading to some kind of civil penalty or the kind of disgorgement that can then result in a payout. So to address that problem, what I propose in the paper is to have a second type of reward, which is a one-time reward for each report that the LDA submits. Now, these reports are not simply SARs. So these are much more in-depth investigative reports. And I'll talk about that more in a bit, but the idea here is to disincentivize over-reporting, but to set it up as if the regulators are paying for quite a detailed investigative report produced by these agents. And so the idea is that these two types of rewards would make an LDA program, make acting as an LDA a viable business proposition, both for large existing firms and also for smaller entrants. Now, there are plenty of risks related to this proposal, and it's something I talk about at length in the paper. And I also talk about the mitigating measures. So just to cover them here, one is over-reporting. So one of the natural reactions here is that, if we're going to have regulators paying for reports, there would be a perverse incentive for LDAs to then over-report, to submit tons and tons of reports. And that would replicate a current problem we have with SARs, where institutions are engaging in defensive reporting. They're just submitting everything they have to try to avoid getting in trouble. That would obviously be non-economical, and it could also be counterproductive. So the mitigating measures I have in place in the paper to discourage this, first and foremost, is requiring that the investigative reports that they submit are quite in-depth. So these would be closer to the type of thing that a private investigatory consultancy would produce, as opposed to a simple SAR. The idea here is to discourage over-reporting. Additionally, there's enforcement. So regulators would have the capacity to fine LDAs, potentially even revoke their licenses if they engage in spurious reporting that wastes time. Another idea that I've contemplated in the paper is licensing. So you could also require that the staff that perform this task for LDAs are themselves licensed. They could be licensed private investigators, for example, in a way that would also ensure that really we're focusing here on quality over quantity. We're encouraging firms to produce a small number of in-depth reports only by those who are qualified to do so. Another risk related to this is selective reporting. So in this system, it would be natural to expect that LDAs will focus on those suspicious transactions that they think will lead to the biggest payouts. Now, I don't think that this in itself is necessarily a problem. Essentially, it means that they'd be focusing on the biggest fish, but there is a slight risk that there would then be, additional suspicious activity that's left on the cutting room floor. And to address this risk, I think that one thing that could be added here would be to create a requirement that if an LDA decided not to proceed with investigating a particular set of transactions, that they would then share that information with the gatekeeper, who can then decide whether to submit a SAR itself. So the idea being is that nothing in this program results in a loss of information reported to the government. Additionally, there are conflicts. So one thing we might think about is, what if the consultancy, for example, performing the LDA, what if they have commercial relationships with the individuals or entities that they are monitoring through the transactions? So this is really a problem that already exists with consultancy in general. It exists with audits, of course. There are informational barrier measures that could be taken. These are certainly far from perfect. We've had lots of examples of these breaking down, but similar mechanisms could be put in place here to try and prevent this. A more extreme option here would be to mandate legally that if you're going to perform LDA functions, that you can't perform certain other business functions. You might even think about trying to, force some kind of split, similar to the kind of thing that Ernst & Young has been considering recently. But the idea is that you could potentially mandate that LDAs can't perform other business functions that could create conflicts. Additionally, there's a risk of regulatory capture, so that a risk that LDAs themselves are captured by the gatekeepers, and they could potentially, be succumbing to an inducement or a bribe to ignore certain activity. This is something that I think, it will always be a possibility, but I think the incentive structure itself of the LDA program would discourage this. It would somewhat defeat the purpose of performing the function itself. And of course, succumbing to an inducement like this is extremely risky, both for a firm performing LDA functions and also the individual staff involved. So I think there are basic legal and reputational disincentives against this risk. And finally, there are two types of what I kind of call market-based risks. The first is that there is a concentration of power within one LDA. So the risk there is that if we had one monopolistic LDA, it could be that they start producing lower quality submissions. It might provide them with some kind of political leverage over regulators. The main, I think way of addressing this problem is to ensure that the LDA program, that the incentive structure is entrant friendly, that it allows for smaller firms to enter the market. And also in more extreme examples, it's plausible that antitrust rules could apply in this industry, this market, just as they would in any other market. On the flip side, state competition. So this is not a system where we want states competing with one another. We don't really want states to be offering different levels of rewards to try and induce LDAs to focus on their own markets. And I think the simplest and most effective way of addressing this would be to have some type of international agreement where regulators in different countries don't compete on price, that they provide equal levels of inducements so as not to create these types of incentives. So in conclusion, this paper really is motivated by a policy challenge, and that the policy challenge is that we really are failing to detect financial crime. And the primary reason, in my view, it's really not technical. There's lots of great people working in the space every day to identify financial crime. And really the primary impediment is the incentive structure that they inhabit. It's the forces of the business that they have to battle against every day. And additionally, on the policy challenge, there's also a theoretical challenge. And that's what I refer to as the surveillance trilemma. So it's that existing forms can't provide these three positive attributes that I think we would all want to have in a surveillance system. And so what I propose in this paper is this LDA program. As mentioned, it's a new class of firms who are licensed and empowered to perform surveillance and provided with financial incentives to report that activity to regulators. A few concluding notes before I finish up. One is that this is sort of all caught up in a wider discussion of public versus private. And I think one thing to clarify is that the The problem with the current system, in my view, is not the involvement of private firms necessarily. It's simply that their incentives are structured in a way that's not positive. And so what this is doing is continuing to allow private sector innovation in this space, but structuring their incentives in a way that encourages positive motivations to report. Another caveat, many country-specific legal complications that I do not address. There's too many to address in one paper. And of course, there's also political complications to potentially creating such a system. And alternatives. There are an infinite number of ways in which this program could be designed. I'm sure that there are many other potentially better ways in which it could be designed. I'm very curious to hear the thoughts of this audience on that. And so it's a working idea. So I really look forward to hearing more thoughts. But the main thing I want to emphasize just to finish off is that we need to keep working on this. I mean, we're working in a world with a system that is not effective. We're paying enormous amounts of money. We are not getting the results we should be. And we're imposing huge costs in the private sector. And I think that there are many ways in which we can craft these incentives more effectively, and we should keep working towards that. And with that, I'll conclude. Thank you very much for your time.
Thank you, Miles. Thank you for your words. I don't want to lose more time, so I pass the floor immediately to Mark for his discussion and then for the Q&A.
Okay, I have about 11 pages of notes from the paper and from the discussion. What I am not going to do is read my 11 pages of notes. You'll be pleased to know. But I'll go in with, and I won't take up a lot of time because then we can get some discussion there. My starting position is I don't agree with the mechanics of the position that Miles has put forward, but I don't disagree with the idea that we need to do something. So let me, having put that on the table, that's my stick in the sand. I'll then talk about some of the specifics around that. I don't call it the gatekeeper model, I call it the regulatory model. Governments introduce regulation through legislation and then the formation of a regulator. That regulator passes obligations onto the private sector and you do what you're told. That's the way the game is played, and that's what unfolds. Now remember, this kicked off back in the 1980s when you could basically run a large bank on an Excel spreadsheet. You can't do that now. I mean, you couldn't then, but you can't actually even come close to doing that now. So transactional complexity, customer complexity is a lot harder, a lot more detailed and a lot deeper than it's ever been, and it's getting worse by the minute. So the concept of writing these rules or the recommendations for the international standard setter and then passing that across over 200 jurisdictions to implement their obligations on the private sector seemed like a good idea, and then evolved to become this mightily complex system of monitoring that we were all part of. And I have to tell you, as somebody who oversaw monitoring financial crime detection for one of the largest banks in the world, it's complex. It's not easy. And the idea that a private sector third party would be able to come in regardless of incentive and do a better job doesn't sit well with me. And I say that because over half of the people that worked at HSBC were brought in from various public sector agencies, governments, data scientists, universities, anywhere we could find somebody who had half a brain and we thought might be able to help. So it wasn't so much a case of the wrong people doing the wrong thing because they weren't incentivized. It was more a case of trying our best to do a good job. So let me come back to that question. When you look at the financial sector and what they're supposed to do, they're really covered under the international standard setter at the moment, more or less, the FATF, Financial Action Task Force, and they're captured under the latest regime of these 11 immediate outcomes. Immediate outcomes 5, for instance, covers this whole thing about customer due diligence and knowing who your customer is. Now, one of the reasons that detecting financial crime within a private sector institution is so difficult is because under the way that we implement the obligations under immediate outcome 5, we're about globally, I think on a country by country basis, we're sitting at about 42-43% effective. So we're not actually writing the rules and putting the laws in place that make it difficult for criminals to launder money. It's actually quite easy for criminals to launder money under the current regime. And that's the observation for the international standard setter. And that's also my personal experience. It's quite easy to launder money. And therefore, most of the money that gets laundered ends up in places like the UK, the US, and the other large financial centres, because that's where the rest of the money is. So you want to keep your criminal money with the rest of the money so it doesn't stand out. So by not being particularly effective in the existing rules, immediate outcome 5 captures most of the recommendations there. Then we're not particularly good at what we should be doing, which is monitoring to make sure that we detect criminals when they try to use the financial system. Then you get to the other half of that, which is regardless of how good you are in doing immediate outcomes 1, 2, 3, 4, and 5, which capture most of the regulatory model, which is the private sector and the regulators and the obligations around due diligence. If you're good at immediate outcomes 1, 2, 3, 4, and 5, the failures of immediate outcomes 6, 7, and 8 fail to act as a deterrent. And we're not very good at investigating, prosecuting, or confiscating proceeds of crime. So even if you were, as a bank, really good at spotting when criminals are using the system, our legal frameworks and structures and incentives in the public sector are actually failing to pick up. So that tells us that we've got more to do than simply having a better way of detecting criminals using the system. So what I'm saying in all of that is, before I looked at having the private sector getting better at spotting, we think these guys are criminals, firstly, we have to make sure that we have consistently applied and enforced laws, which we don't have at the moment. And secondly, that we have a public sector that is set up and incentivized and enforced to actually take action, to get that prosecution in place, or the investigation, prosecution, and confiscation of criminal assets when the opportunity arises. And that's something that is supposed to act as a disincentive for criminals, but also a penalty for criminals. And then if you do it properly, which is what the many nations are trying to do, such as the US and half of Europe, then you use those funds to reinvest in some of your detection capability. So that's the first bit. I don't think the assumptions are right in the starting position. I think some of the mechanics suffer, and Miles, you picked up on some of your risks there around how it might operate. One of the questions that came up 2010, 11, 12 is why don't we just have a positive incentive for the banks, and I'll generalize by calling it banks, to catch these criminals. So if you catch a criminal, you get to keep part of the money. Now, of course, that sounds good if you say it really quickly, but there's two things you need to be aware of. Firstly, you have a moral problem where some of that money that you think you're keeping because you've done a good job in obeying the law actually belongs to your customers and was stolen from your customers by these criminals. So you're now saying a positive incentive is for me to keep some of that money that was stolen from my customers. Your shareholders won't treat that one very kindly. And secondly, financial crime tends to operate across multiple jurisdictions, across multiple institutions. So you get into a bit of a bun fight around who keeps what percentage of which money that gets captured. And what I found when I was thinking this particular one through, that also applies in the LDA model, where you have that sort of bun fight between jurisdictions, between LDAs, as to who's going to keep what percentage. And I know you can put in place laws and so forth, or regulations or guidelines to capture that, but it is one of the things that you would need to look at. And it's mentioned in your risks, but I think you will find that that particular hurdle would be quite a difficult one to overcome. And I say that because it's taken us 30 years of the existing recommendations to get to a point where countries across the board universally are 76% technically compliant with things that were introduced in 1989, and they're about 44% effective in those same recommendations. So to introduce something else into there and say, we think this is going to be better, probably fails to understand why that absence of effectiveness is there across the board. So not just in the private sector, but across the board at that intergovernmental level. And I think that will be one of the things that would need to be overcome. And I'll finish up in a minute, so we've got time to discuss the the operation of this between an LDA and the financial institutions and the potential for conflict, I think there's a little bit of work that goes into how you would sort that out, because my experience working with several thousand talented, very, very talented professional compliance officers in one of the largest banks in the world suggests, and whenever I dealt with some of the consultancies, we actually had a better tribe than they did. Now, I'm aware that I've just sort of put my shirt on and my team shirt on, and I've said something controversial, but that's what happens. We employ the best, we pay them an awful lot of money to be the best, and we expect them to do as good as they can given the regulatory environment they're operating in. For somebody else to come along and say, actually, you know what, we think we're better, that creates an awful lot of conflict potential, which might, rather than actually help with the current system, would probably act as something that's going to dilute focus and undermine the whole intent. So there's something to be done there around making sure that that conflict isn't there, but you're actually using a new regime to supplement or to add to the existing regime. So I think maybe look there, and I'll stop with my final point, that going back to where we are with the 11 immediate outcomes, where we're operating at about 44% effectiveness, I would like to see us get better at what we're supposed to be doing now and evolve that incrementally as we look at where are the areas of weakness that we can seek to improve, rather than say, let's add an additional regulatory regime in here, and it would need to be a regulatory regime that we can use to replace parts of this that we think are broken. So that's I'll stop there, and I'll hope to take questions, or we can open it to the floor for general discussion.
Thank you, Mark. Thank you indeed, Mark. I am a bit time conscious, so instead of having Miles responding to Mark, I would maybe collect some further comments and then leave the final 5 minutes to Miles to answer, if there are. Mark, yours? Yeah, please start.
Thanks, Miles and Mark. And Miles, I appreciate the effort to sort of take on this problem. I guess, I mean, I have a lot of comments that I'll send you separately for the sake of time. 2 points, though, that I would address. One is actually about Mark's comments, and somewhat boldly on my behalf, disagreeing a little bit with Mark's, since he knows a hell of a lot more about this than I do. But it seems to me that those comments start with the assumption that the FATF standards are correct to begin with, right? And that is, the goal shouldn't be to necessarily make sure we're sort of implementing FATF rules if we think FATF rules aren't necessarily correct. And so what I like about, I'll say this, like what I like about the approach, Miles, is I think it doesn't necessarily assume that, right? It's sort of an inductive rather than deductive approach to this. And that is, let's not assume FATF is right. Let's go see if money laundering is happening. And so I think there's enough questions, especially in this group, maybe around FATF, that approach is attractive to me, right? So that one point of like, it does represent a very different approach that I think is potentially positive. My biggest red flag in this is, Miles, is the fact that banks won't be held responsible for anything found by LDAs. In which case, if I'm a bank, I go, sweet. I get to fire Mark, and I get to fire his thousands of staff, right? And that saves me tons of money. And I don't have to worry about money laundering, which I don't really give a damn about anyway. And so, right? So then what incentives, speaking of incentives, it's all about incentives, like where are the incentives for banks then to say, we're going to go after money laundering, because we can basically outsource it to the LDAs. And if they find anything, we'll say, oh gosh, we're sorry, and then we'll fix it.
Thank you, Mark. Joris, and then Peter.
Yes, thank you, Miles. I think a very interesting paper, very refreshing to have some very new ideas. We have a lot of papers on why the current system is failing, but taking up on the task and coming up with new ideas is, I think, very refreshing and very interesting to all of us. Yeah, I also have, as Mark just said, this problem of pushing the responsibility away, and that this could be a potential risk. And while maybe let me say in general that, of course, when you come up with a new idea, our first intuition is perhaps to shoot on the idea and what is wrong with it. But let's face that even when we do point out some disadvantages of a new system, we should recognize that also the current system has huge disadvantages. So even if a new system has disadvantages, it can still be a better system than what we have now. But let me do exactly that and talk about the fact that these LDAs will get access to data and that they are profit driven, which is indeed a positive incentive for them to do that. But at the same time, they have access to data that is valuable in itself. And so you might create a new risk in terms of an incentive to sell this data or to use this data for other purposes. When I work with banks, they're always very hesitant to share their data. And part of that is because they're not allowed to share data, but also because they think competitively there is a lot of information in this data that they don't want to share with other banks. And now you would have these LDAs that might have access to bank data and perhaps even to multiple bank data, which might create an issue in itself as well. And maybe one last thing on what Mark Turkington also mentioned in terms of the private and public. I think also in the public sector, we have this wrong incentive that we opened the floodgates by saying the private sector should help. This privatization of security created this possibility for a Minister of Justice at the end of the year when all budget is out to still do something that's completely for free, but that can be effective. And that's just yell, banks should do more. That's completely for free. Minister can just yell that. And it seems like they're doing something. And they can actually do something that way. The banks might start to do more and that might be effective. But if there is no funds to actually do something with all the new information that comes up, you create a huge bottleneck. And that's what I've been seeing in many countries where the efforts in the banking sector keep going up, but in the public sector, there's not more budget. And so you create a more and more of a bottleneck in that sense. Let me leave it at that and give the floor to
thank you, Peter. Mark, please be short, and then back to Miles for closing.
Sure. Actually, my principal concern is Mark Turkington's comments that the existing system consists of people who are who are very capable and well motivated. And I mean, one striking characteristic of some of the big cases is that the board of directors turns out to be quite unconcerned about money laundering. I mean, the Danske Bank, I mean, the board of directors knew what was going on and were totally comfortable with it. And I think that the incentive problem that Miles points to, and Joris has made the same point elsewhere, is very fundamental. And I'm not sure if Mark's going to have a chance to respond, but I really do challenge the motivation issue that he raises. Thanks.
Yeah, look, I will be very quick on that motivation, Peter. Look, you're absolutely right. There are those issues, but I would argue that for every case where there's a poorly motivated board or directors or executive, you'll find many who are quite motivated and incentivized to do the right thing. And I've worked in a lot of those banks or with them. What I wanted to say, and looking at my notes, I completely ignored my opening position because I was sort of racing through various notes that I took down. One of the things, and Miles, this will help lead into your response. I think change is going to happen whether we like it or not. It's happening now. It's being driven through technology. It's been driven through some of the things, the capabilities that are being produced. And this idea that a private sector institution will monitor its own customers using these fairly blunt technologies, and I was an expert in deploying them, that's going to be quite antiquated. And some of the capabilities that are being thrust into the market now as new capabilities will see that thinking, the thinking that drives that expectation undermined. And now what comes out of that, I don't know. And Miles, this is why I welcome this paper and some of the discussion that it creates, because I think we'll find that the next 3 to 5 years, we will be having more and more discussions around what do we want to see, how do we want it to operate, how do we deploy these new technologies. So I'll leave it there and I'll hand back to Miles, and thank you again for inviting me to have a chat.
Thank you, Mark. Miles, the ball is back to you.
Great. Well, thank you for the comments. It's super helpful and very interesting to hear the perspectives. And I think there's a couple of big themes in the comments that maybe I should address as a priority. And one is that there's a couple of comments that, you know, the problems with the system are not just in the private sector. There's also lots of issues with the public sector component of this, and that I completely agree with. And it's something that I try to get across in the paper and the presentation. Maybe it needs to be emphasized more. And I think that, you know, this paper it's trying to address a relatively narrow component of the system, which is the detection component. But there are plenty of post-detection issues that the system will not solve. And so that's something that I very much acknowledge. And I think I'll work to make that more explicit in the paper. Another point, Mark Turkington, that you brought up that I'm also sensitive to is I certainly do not mean to and try not to imply in any way that the compliance staff of these institutions are not the most capable people, and that there are other people that come in that can do this better. It's actually, the point I'm trying to make is quite the opposite, that there are great people working on this problem within these institutions, but that in many ways they oftentimes come up against the counter commercial incentives, the counter commercial forces that are there. You know, it can be all kinds of subtle ways. It can be the involvement of front office managers in decisions to submit a SAR. You know, it crops up in all kinds of ways. And I think we see that in the enforcement actions. But I think it's also something I'm going to work on trying to make more explicit, to emphasize that this is not about implying that there are better, more capable people. It's about that there's another system where they would have different incentive structures. They wouldn't have the same kind of commercial barriers on their activities that might be encountered within the institution, just as a general point. A couple of other comments on some of the specific mechanics of the program. So the point about banks not being held responsible for what the LDAs identify, it's tricky. It's tricky. I agree that it's a tricky one. I've been trying to think about how to structure this. The problem is that if they are responsible, I think the problem becomes that all of a sudden it becomes about the LDAs investigating the gatekeepers rather than the underlying clients. And so the idea, as I'm conceding in the paper, is that these gatekeepers would still have their current obligations. They wouldn't change their obligations to have their own compliance programs, do their own monitoring, do their own SAR reporting, et cetera. You would be adding an additional aspect to the system in which there would be this other set of agents who are looking at the clients directly and not trying to investigate the LEAs themselves, because then it would pit them against each other. But it's tricky. It's tricky. So it's the devil will be in the details for sure. And the extent to which I can go into it in the paper is slightly limited. So I'm kind of hoping that it will inspire further thought on this, and maybe someone else can get into those details. We'll see. But I do take the point. I think that those were some of the big ones. There are a couple of other small comments here which are really useful for me. You also raised, Mark, potential moral objections to this program. That's something that's also been raised with respect to some of the existing incentivization programs that are in place. One objection to the whistleblower model, for example, is this crowding out effect that's been theorized, that the incentives to actually do the right thing are somehow disrupted by this monetary incentive. The existing empirical evidence that I've read, that I'm aware of, has suggested that's not a huge problem. But you know, nevertheless, I think you're probably right. There is a risk that there could become some confusing moral dilemmas in place here, and that would definitely need to be addressed. And your point about, you know, how exactly do you split this money if there's multiple actors involved, multiple jurisdictions, is also well taken. And I don't have an answer to that, but I think it's something that could be figured out in the long run. But I do take the point that it's definitely a challenge. So I'll stop there. But thank you, everyone, very much for your comments. It was super helpful and very interesting to get your perspective. I appreciate it.
Well, thank you, Miles. There are also a few comments in the chat by Jay, by Julia as well. And I don't know if Jay, do you want to intervene shortly? Otherwise, we keep in the chat. This will be recorded. Yeah, so we can close the meeting. And thank you, Miles, for the discussion, and
Michele,
to Mark
Peter's
also
got-
for the discussion
Michele,
as well.
sorry,
Yeah,
Peter's
Mark.
got his-
Yeah, please.
Peter's
Yeah.
got his hand up. I don't know if he has another comment.
No.
Okay.
Just let over.
Yeah. So you see, Mark, you were invited as a discussant, but then you had to address some comments as well. So this is the spirit of Money Laundering Research Network. So thank you again. This will be put on our website, and see you next month for another webinar. Thank you again. Bye bye.